Welcome to our meetup for this evening, April 22nd, 2014, year of the NSA and ALEC. I'd like to introduce you to Rainey Reitman. She's with the Electronic Freedom Foundation, and she's the activism director. She's also a writer, a privacy advocate, and a person who advocates strongly for government transparency. And we all know that that's one of the things we were promised in the election of 2008 was a whole bunch of transparency, and I see a whole bunch of opaqueness. So, somewhere along the line that got mixed up. She's also founder of two organizations, Freedom of Press Foundation, which is extremely important, although with our press of Fox and CNN, not much to say about them, but there are some news organizations out there who are trying to do good work, and we need to make sure that they're free to follow those stories that are really important, and that journalists are not out there being shot for going to get a story to inform us. And she's also a founder of the Chelsea or Bradley Manning Support Organization. And of course, Bradley Manning was the soldier who released the documents to WikiLeaks that let us know what was going on in our government. Unfortunately for him, he was tortured, but that's a subject for another meetup. But the fact of the matter is that we need this information about what's going on in our government.
So my name is Rainey Reitman. I'm the activism director of the Electronic Frontier Foundation. How many of you are familiar with EFF? A few of you? Okay, there's a couple that aren't. So EFF, nonprofit civil liberties law and advocacy center. We focus specifically on how your rights are threatened or endangered by new technologies, and advocate for your rights in both courts of law and in Congress, and also build technologies that can help you protect yourself when you go online. We believe that when you log on, your rights should go with you. And I'm going to talk a little bit about the NSA. And I'm going to keep my comments really brief, but I think it's really important that people, especially politically active people like you guys here in this room, understand what the legal framework is that the NSA is operating in and where it's not operating within that framework, and have just a real simple concept of what the NSA is doing. And then I want to talk to you a little bit about what is EFF doing as far as what are our lawsuits against the NSA, and what are the advocacy avenues for actually preventing this type of mass surveillance. And then I'll kick it over to Chris and he'll keep going. So when we think about how laws are made in the United States, many of us think about the whole process of we elect members of Congress work out legislation, they reach agreement, it passes out of committee, it passes that down to the floor, it gets enacted into law, it gets signed by the president, you've got a law. There's this other way that people make laws in the United States, and that is through court precedent. We all think about this, but it's a little bit, it's not intuitive. It's that the courts themselves interpret what laws mean in the United States. And so in many ways, the courts are a body that is making law, that the law that you and I live under is what the courts decided they would interpret. And I think it's really important when we talk about the NSA to remember that really important function of what court precedent does and how we all live under a body of law that's created by a court system. So last year in June, we were all really shocked and really amazed to see The Guardian publish a document. It was a FISC order. It was an order that showed that Verizon business records, so anybody who's got their telephones under Verizon, were being swept up en masse by the National Security Agency. And that this was a 3-month order that said all Verizon business records, all phone records were going to go directly to the NSA. And the actual document itself was published in The Guardian. And Senator Einstein then said that this document was not unusual, that in fact, this 3-month document was identical to similar orders that had been signed every 3 months for 7 years in a row. And the Wall Street Journal later reported that it was not just Verizon, but in fact a whole range of major telecom companies. The end result being that you and I now have evidence that the government is collecting our telephone records, even though you and I are not suspected of any crime. So many people then said, well, what is this FISA order? Who signed this? Well, who said that this was okay? This order was signed by the FISA court, the Foreign Intelligence Surveillance Court. Now this is a court that was put together in 1978. It was actually supposed to be a method of stopping abusive surveillance tactics by the federal government. And it was designed to oversee federal attempts to government applications to conduct surveillance. And we don't know that much about this court because it operates in extreme secrecy. In this courtroom, there isn't your typical courtroom where you've got your judge and your jury and you've got your defendant and you've got your prosecution. It's not like that at all. It's a closed room, and the only people that can go in are the judge and the government. The government shows their documents to the judge signs off on them. It is a rubber stamp court. And then you and I never know exactly what it is that they found out. And in fact, the FISA order that was published by The Guardian was our first real glimpse into what the FISA court is doing. So I know I made this big deal earlier about how courts are interpreting the law. And the reason I made that big deal is because I want people to understand that the FISA court today is not just signing off on simple orders. They're actually producing lengthy, extensive legal interpretations, dozens, hundreds of pages long, perhaps. And that these are interpretations of how the United States will be interpreting its own surveillance law. And these documents are under seal, which means that the law under which the National Security Agency is operating is a law that you and I do not have the ability to go and read. It is a law that is secret. And when a secret court makes a secret interpretation of the law, that results in a secret law. So the United States has, and it's unfortunate and it's frustrating for people at the EFF and for the ACLU, but we have a situation where we don't get to know the law the way we ought to. Now this makes it very difficult to reform the law because it is extremely challenging to write adequate legal reforms and to advocate for those reforms when you and I don't have the ability to actually go and read what the law says. I'm going to talk a little bit about, and I think I'm actually don't have that much time, so I won't talk much about it, about one particular element. And that is a part of the Patriot Act. You're all familiar with the Patriot Act, I assume? Yes. A part of the Patriot Act known as Section 215. This is often considered the library records section or the business records section of the Patriot Act. This section of law says that the government has the ability to get records that are tangible and relevant to an authorized investigation. Again, tangible records relevant to an authorized investigation. The FISA court order that we saw produced and published by The Guardian was an interpretation of this section of law, Section 215. And so the government's argument was that your phone records and his phone records and your phone records were collected because they were relevant to an authorized investigation. You might be thinking, what on earth could my records have to do with an authorized investigation? Not only your records now, but every record for the last 7 years, all your phone records going forward. And the answer is, we didn't get to see what the government argued. We didn't get to see what they argued in courts, and we didn't get to see what the courts had then interpreted the law to be. And that has been subject to extensive legal fighting. EFF has been fighting in courts to get access to the legal interpretation of Section 215, as has the ACLU. And we've had some success, but we don't have, for example, the government's legal arguments. So that's one of the things that the NSA is doing, and that's a little bit of how they're going about doing it. The NSA is doing a lot of other things that you may have heard about in the news, including sweeping up internet communications of millions of people worldwide, including people within the United States. We have whistleblower evidence that predates Edward Snowden, indicating that the NSA is receiving tons of internet communications of Americans. We also know that the NSA is undermining encryption. So encryption is the beautiful, magical way that you and I can use the internet today and use technology and feel secure in it. It is the way that you know, for example, that when you log onto your online banking, it's actually your bank that you're talking to, and that those are secure transactions. It's how you know that you are able to send emails and the person next to you in the coffee shop isn't reading them at the same time as they're transmitted. It's the way you're able to buy things on Amazon.com and feel secure in it. And it is frankly the way that we know that air traffic controllers can communicate and all sorts of other people can do things. Our whole world relies on computers, and our whole world relies on strong encryption. And one of the things we found out, and I think in many ways the most disturbing thing we found out about what the NSA is doing, is that they're working hard to undermine encryption, to make it more difficult for technology companies to have really strong, really powerful encryption. And I think that can have, that has ramifications now, but that could have serious ramifications for the health of the internet and health of technology for decades to come. And I would also like to just mention that what we know now about the NSA is the result of leaks. 5 minutes, I'll wrap it up. And there's probably much, much more that we will learn. So there's a whole bunch of things that we're doing about this. As I mentioned before, EFF is engaged in lawsuits, so we have a impact litigation team that is fighting the NSA. We're fighting them in court on both the First Amendment and the Fourth Amendment. Our most recent lawsuit against the NSA, we're representing 22 different clients from a whole range of political spectrums that are saying that this is affecting their First Amendment rights to assembly. We're also engaged in advocacy. That's the part I do. I've thrown a rally in Washington, D.C. We've had days of actions. We most recently had a day of action in which over 90,000 people called Congress and demanded an end to mass surveillance. We're working to do international pressure and pass UN resolutions against this type of surveillance, and we're also working for technical solutions. I wanted to kind of wrap up by talking about, what can you do? And the most important thing you can do, well, there's actually a whole bunch of important things you can do. We'll take that next time to talk about it. The first is ACLU and EFF and these other civil liberties organizations. We obviously rely on our members to stand with us and support us, so that's one thing. But it really, being a member of an organization is just one tiny, tiny part of it. The rest of it is being willing to speak out. Being willing to, for example, meet with your member of Congress or with their staffer when they're in your home district, to pick up the phone and call your member of Congress and say, I'm concerned about this, write a physical letter, or even just sign an email petition. I also think there's an incredibly important role for politically aware citizens or individuals to educate others. If you understand that this is an important issue, then you should be telling your friend, and if you think it's an important issue, then you should be writing an op-ed and publishing it in a local paper. It's something all of us can do, and it makes a huge, huge effect. I would also say there is a wonderful organization local here in San Francisco called the Shame on Feinstein Coalition. And they are working to push Senator Feinstein to, Senator Feinstein has been championing a bill that would try to entrench surveillance, try to codify into law the worst aspects of NSA surveillance. And the Shame on Feinstein Coalition is pushing back in a big way. And I would just end by saying that there's a really powerful reform proposal moving through Congress right now. It's called the USA Freedom Act. I'm not going to lie to you, it does not do everything I would like to see it do. There's a heck of a lot more that we need to do to stop NSA surveillance. But it's a bill with a ton of co-sponsors, it's moving, and if it passes, it could well be the most important surveillance reform in our lifetime. And so this is an unusual opportunity to try to push for reform, and I can't possibly urge you enough to do what you can to help us get the USA Freedom Act passed, and then to push for additional reforms. I will now kick it over to my friend Chris.
All right. So thank you. My name is Chris Connolly. I'm an attorney and technologist with the ACLU Northern California. How many people know what the ACLU is? So we're sometimes known as the EFF of the real world, but most of the time we are known as the nation's largest and oldest civil rights and civil liberties organization. We have over 500,000 members. We have affiliates representing all 50 states, District of Columbia, Puerto Rico. not Guam, sorry. But we represent all sorts of rights. So we have been increasingly focused on the world of technology and especially on the NSA because, as Rainey said, that technology is impacting all sorts of facets of our lives, and we find it incredibly important to recognize that even the more traditional ACLU rights of equality under the law and freedom from discrimination based on sexual orientation or health condition or everything else is dependent on how we relate to our technology. And so we have focused quite a bit of time and effort on working on government surveillance and other technologies that can erode our personal freedoms. So Rainey's covered a lot of ground, so I will fill in the gaps, and I will kind of take the high road and the low road. The high road, I want to talk a little bit about the Constitution and how that applies to the whole NSA situation. And then I want to go down low and talk about how the NSA's mentality has been filtering down to local law enforcement and how that plays into the whole surveillance equation. So the high road is the Constitution, and as Rainey said, there are multiple sources of law in the United States. Some of them are passed by Congress, but the fundamental law is the United States Constitution. And the Fourth Amendment gives people the right to be secure in their persons, sorry, I always forget this, persons, houses, papers, and effects against unreasonable searches and seizures. That is the fundamental privacy right under U.S. law. But what happens is that as the 200 plus years since the Constitution was written go by, courts have interpreted that to determine exactly what it means. How does it fit into the context of the modern world, which is very, very different from when the Bill of Rights was passed and the Constitution was signed. And one of the fundamental changes in this law came in the 1970s. And there were a pair of cases called U.S. versus Miller and Smith versus Maryland that established what's known as the third-party doctrine. And this doctrine, put succinctly, says an individual does not have a reasonable expectation of privacy and therefore constitutional privacy protection in a record that is shared with a third party for business purposes. That has opened up an entire world of things because this was written again in the 1970s. This is not what a cell phone looked like in the 1970s. It came with a shoulder strap. It was a box. It had no location awareness. It was not able to send email or text messages or anything else. But the technology has radically changed since then, and the legal interpretation has not. It is starting to happen because of the NSA, because of other things, but technology is moving much, much faster than the courts and lawmakers can keep up with, which is why we have been getting into so much advocacy around not just the law, but also technology, personal activism, democratic processes to try to address the situation, because we think it's fundamentally difficult for the law to ever keep up with the pace of technology. So I'm going to try to hit on the notes that I had and then I crossed out because Bernie talked about them. So one of the things that we focused on is indeed Section 215 of the Patriot Act, which allows the collection of business records, also broadly known as metadata. Metadata is not very well defined. There are lots of people using lots of different definitions, but generally speaking, it becomes all of these business records. Things like your location. When you carry around a cell phone, in order to receive calls, your cell phone has to communicate with local cell towers. That means those cell towers know when they saw your phone. If those records are available without constitutional protection, there are serious problems when you have government agencies who are eagerly sucking these up. It could include information about your use of the internet. Email, there have been arguments that the to and from lines of your email addresses are metadata, are not subject to constitutional protection. There are many, many different things that the NSA is not telling us. We know that Director of National Intelligence, Clapper, lied to Congress or misrepresented. He wasn't aware of all the ramifications. It wasn't intentional. It was just, it just happened that they were sucking up all sorts of things about American citizens. Right. His mind was somewhere else. But we also know that the NSA has frequently violated even its own internal rules, both in terms of how they use the information. There's an entire class of internal incidents called LoveInt, where NSA analysts have spied on their significant others using the technology. But there are also multiple indications that they are sharing information with other agencies, and then laundering the information so that no one can see where this information is coming from. So they'll share with the DEA information that they gain from national security purposes, with the understanding that DEA will then backtrack, use this information to find someone, but then come up with an alternate explanation for how they knew the person was there so they don't have to admit where they got the information, because it violates the NSA's own rules. So what we're seeing is a system of safeguards and checks and balances that are being consistently ignored. And again, what we're also seeing, I'll move on to this because I know my time is going quickly, is the same mentality that is drifting not only from the NSA and from the federal government, but into local law enforcement as well. And we've seen this in a few specific technologies, and I'll name off a couple. The one that Max referred to that I was telling her about just before this is called stingray. Does anyone know what a stingray is in this context? All right, Rainey knows. Why am I not saying this? So, as I said, the way your cell phone works is that it has to connect to nearby cell towers. It essentially, as you're walking around and you're moving, it reaches out and says, hey, I'm here. Is there a cell phone here? Is there a tower nearby? Because if so, if someone tries to call me, please pass my call on through. That's how cell phones work. What a stingray is a fake cell phone tower. Really, that's all it is. It acts like a cell phone tower. It will respond if a cell phone says, are there any towers nearby? What's your number? How can I register if I want to send a call? It will pretend to be a cell phone tower, but it's not. It is a device made by a company in Florida that is intended to track cell phones without even going through AT&T or Verizon or anyone else, even though they're very happy to cooperate. Sometimes even that seems to be too much. So this is pernicious in many ways because location can be used for all sorts of purposes. But one of our deepest concerns about this is it has been consistently and very intentionally clouded in as much secrecy as possible. Perhaps this would be funnier if it wasn't true. There was a recent case in Florida where two police officers came to someone's house, knocked on the door, were refused entry, forced their way in and searched the house without a search warrant. What came out in the ensuing court case is that they had used a stingray to try to see if someone was inside the house. But then they signed a non-disclosure agreement with the company selling the stingray, saying they wouldn't tell anyone about that, and interpreted that as meaning they didn't have to tell a judge why they knew the person was inside so they could get a search warrant. So completely undercutting the entire idea of transparency and checks and balances under the mentality of this is all secret because it's more effective if nobody knows what's going on. And we're seeing this in other cases too. We're also seeing more and more government agencies collecting, having the mentality of more data is good. We'll figure out the safeguards and the privacy consequences later. We're just going to expand our technology. Another topic I'll touch on there is the Domain Awareness Center in Oakland. Are you familiar with that particular story? So this is another trend which we're seeing, which is the Department of Homeland Security issues grants to local law enforcement agencies for all sorts of things. Berkeley somehow has a tank. I don't know why Berkeley has a tank, especially Berkeley having a tank. But Oakland applied for what they call the Domain Awareness Center. It was originally described as port security. They were going to use this to network together cameras in the port, to secure the premises, to have, to do a contained environment. And then someone got the idea, well, why don't we tie in everything in Oakland? We'll take the cameras in the streets, and we'll take our ALPR records, and we'll take everything, and we'll tie it all into this great Domain Awareness Center. They always come up with creepy names for these things, by the way. Domain Awareness Center, Total Information Awareness, there's so many things. Maybe a PR person. But anyhow, the idea became something that, the scope just dramatically increased without any kind of, hey, wait, is this a good idea? What are we sucking in? How are we engaging with the public to have this? Now, fortunately, they had to engage with the public because they had to work with the city council. And the city council, because of advocacy from ACLU, EFS, many others, actually scaled it back to the original proposal, which was port security, and not let's know everything that's going on. But Oakland is not the only city thinking this way, and domain awareness and networking cameras together is not the only technology that people are pushing for this. There are more and more cities that are thinking more data is good. And in many cases, they're right. Knowing things about traffic can help you build better roads. But tracking individual people can tell you who's attending a rally, or who's going to a clinic, or a job fair, or all sorts of very personal things. And so our role in the local arena has been very heavily on pushing for transparency, process, oversight, checks, and balances. Not to say that you don't ever think about using technology, but the idea should be you don't just simply roll out the technology first, tell people next, and figure out the safeguards later. That's the wrong approach. The first thing to do is assess the actual consequences of technology, both good and bad. What purpose are you getting this technology for? How are you going to how is it going to actually serve that purpose? There's lots of evidence that, for example, cameras installed on streets are not terribly effective at fighting crime. They are expensive. They do not necessarily work. Sometimes they shuffle crime a little bit away. They can be effective at addressing certain kinds of crime. Acts of violence, they very rarely are because they're usually spontaneous and not based on, well, there's a camera there, so I'm going to, beat up my partner. But anyhow, you have to assess whether something is actually valuable, as well as the cost to this technology. And that really means thinking about what kind of information is being collected, how could it be misused, What is going to expose about people? How much is going to cost to keep it and run it and train the people who need to manage the database? What are you going to do with it at the end of the day? And then actually go through the democratic process, which again is why I'm glad all of you are here, because it's really essential that this is not a decision made behind closed doors by the NSA or the FISC, the Foreign Intelligence Surveillance Board, or by local law enforcement or government. This needs to be something that has input from the community. And the community may well be very interested in having safer streets. Community should, I mean, that seems very reasonable. They may be interested in improving healthcare by understanding, medical trends better. But it also has real concerns about what happens when communities of religious groups are monitored. How does that erode the actual relationship between law enforcement and this group in a way that actually undermines the supposed protections that this technology or this practice is supposed to give? What are the consequences to freedom of expression if there are cameras in a public square and every time you want to go to a rally, whether it's a Shame on Feinstein rally or anything else, that's being recorded? And maybe your picture is being taken and facial recognition is applied and it's being matched with your driver's license photo. This kind of really changes the dynamic for public engagement. And therefore we need public engagement around whether or not and how we use these kind of technologies, around what kind of safeguards are in place before they're put into play, and around how we continue to evaluate and continue to think about this. Because, as I said, technology moves really, really quickly. And something that can do one thing today will be able to do 10 different things next week. Without really constant oversight, and that means vigilance by the community, as well as by organizations like ours and EFF, it's going to be really difficult for just one law that was written one day to keep up. And so that's kind of been my advocacy. Much of my work is around how can local communities really engage with their governments to make sure that local law enforcement is not playing into the mentality of we are the police. The government in a democracy is accountable to the people and not the other way around. And we think fundamentally that requires transparency, that requires input from the community, that requires the sorts of things that we don't see with the mentality of the NSA, which is it's all secret, just trust us. Because the ACLU, notoriously, we're many things, but trusting of the government is not one of them. They do good things sometimes, but we don't take their word for it.
Look, what's my image doing there?
It was a story that set a new benchmark for bad landlords.
The defendants sold.
What?
Your TV is
Oh,
spying.
yeah, sure.
Look, what's my image doing
It
there?
was something that they were
What?
praying
What
for,
image? What are you talking about?
luckily my brother and I were in a position to.
My image was on my camera
to
from
the-
your TV. How
the
did the TV get
resiliency
my
that you
image?
see is
That's all I want to
amazing.
know.
You know, the
I
joy
don't
on
know.
their face.
I'll show you what
just
I'm
to
talking
meet
about.
Now
us,
it's not
let
working.
alone
Hold on. It
for,
was working, but now it's
you
not.
know,
Okay, just give me a
Look.
second.
Flip the switch on it.
And that was it. Then it goes on to the other story. Goes on to this one.
And who
Look.
wants to have that insurance by the first of the year.
It does it
Yesterday,
every
a group of
time you go to
Lucy
that
Brooklyn
part of the
students
screen.
went door-to-door
My
spreading the word about
image
tomorrow's
comes up
deadline.
right
They
because
called
it's
themselves
whatever the
Covered
TV
Berkeley
is
Brigade.
looking at.
Healthcare
In other
workers
words,
from
your
SEIU
room is
also
being
posted
filmed by your TV. Watch, look.
Wiped.